Welcome to the RAN Mutual Assurance Employers Information Briefing. In this video, we will discuss the benefits your employees enjoy with the RMA membership while helping you understand how our procedures work. RAN Mutual Assurance is the administrator of choice for occupational injuries and diseases, as well as for non-work-related health and insurance benefits for the mining, iron, steel, metals and other related industry sectors. As a company that is compassionate and caring, we ensure that your employees and their families receive the care and compensation they are entitled to when the employee suffers from an occupational injury, disease, or dies as a result of such an injury or disease. RAN Mutual Assurance, a non-profit organization, was founded on the 1st of June 1894. RMA operates in terms of Section 30 of the Compensation for Occupational Injuries and Diseases Act 130/1993 under license from the Minister of Labour. The RMA board consists of one independent chairman, 2 executive directors and 14 non-executive directors. RMA's regional branches are located in Carletonville, Durban, eMalahleni, Johannesburg, Klerksdorp, Kimberley, Pretoria, Rustenburg and Welkom. Our satellite offices are situated in Lesotho, Mthatha and Mozambique. Contact our contact center on 0860 222 132 should you require any further information. Beneficiaries receiving a pension in 2013 include 6,789 pensioners, 8,706 widows, 3,792 child beneficiaries, and 101 additional children who were added to the family allowance after receiving special permission from RMA. We are dedicated to ensuring that employees and their families receive the compensation that is due to them. RMA goes the extra mile to ensure that this happens. To this end, in December 2013, the compensation to premiums ratio was around 80%. Turnaround times for claims processing took approximately 30 days. More than half of the fatalities and pensions were handled within 6 weeks, and medical invoices were paid out within 7 days. Provisional settlement powers are dispensed according to sections stated in the COID Act. Employers must register their employees with RMA in order for them to receive benefits. The employee may be entitled to receive compensation for medical treatment, temporary total disablement, and permanent disablement in the form of lump sums, disability pensions or fatal benefits to the family in the case of an employee's death. Claims must be submitted to RAN Mutual Assurance in terms of Section 38, Section 39, and Section 68 of the COID Act. This ensures that the employee, in return, receives their due compensation in terms of Section 73, Section 74, Section 47, Section 49, and Section 54. Please take a moment to scan the listed sections in order to familiarize yourself with the requirements and benefits according to the Act. When claims administration is not handled correctly, RAN Mutual Assurance faces a number of challenges, which affects either the turnaround time or benefits that are due to the employee. RAN Mutual Assurance aims to process claims quickly and award the correct amount of compensation where it is due. To ensure an efficient claiming process, it is vitally important that employers complete all our registration and claims documents accurately. Some of the challenges RMA encounters include reporting delays, incomplete claim documentation, incorrect earnings declarations, a lack of contact details, and over-servicing. These challenges are often followed by financial loss to the employer, the employee, the service provider, and RAN Mutual Assurance. This could lead to the employee facing financial hardships as a result of underpayment of compensation. Claims costs will escalate and penalties may be imposed on members for non-compliance. The Compensation for Occupational Injuries and Diseases Act defines the term accident as an accident which occurred out of and in the course of an employee's employment and resulted in personal injury, illness, or the death of the employee. While Section 22 of the COID Act names exceptions to this clause, it is necessary to understand that out of means the accident is only causally connected to the employee's duties. In the course of explains that the accident happened as a result of the employee's work-related activities. Section 22 of the COID Act states that no compensation will be awarded following an accident if it occurs as a result of willful misconduct on the part of the employee, unless the accident results in serious disablement or the employee's death. Section 22 also states that the transportation of an employee free of charge to or from their workplace for the purpose of their employment in a vehicle driven by either the employer or one of the other employees, and which is provided by the employer for the purpose of the transportation of the employee, shall be considered to take place in the course of the employee's employment. This does not cover injury or death of the employee should the employee be transported to the workplace by a third party. The COID Act stipulates the benefits payable to employees. These cover days off, permanent disability lump sums, permanent disability pensions, fatal pensions, funeral, and medical costs. Occupational diseases are stipulated in Section 65 of the COID Act as any disease that has arisen out of and in the course of employment. This covers Schedule 3 occupational diseases. This presumes that if the employee is exposed to the risk factor, the scheduled disease is the result of that exposure unless proven otherwise. In addition to COID, RMA offers non-COID products which include the Stated Benefit Policy, hostile hazards, sports injuries, riot and strike, as well as the Commuting Journeys Policy. Hostile hazards result in a failure on the employer's part to maintain hostile dwellings, premises, and facilities. That being said, the injured person must be an employee who lives in the hostel full-time. To receive compensation, the accident must occur as a result of a risk inherent to hostel dwelling. Hostile hazards must be reported in the same manner as described in the COID Act. Cover for these injuries include medical aid, temporary total disability and permanent disability to injured employees, and fatal benefits to the dependents as prescribed in the COID Act. Sports claims refer to bodily injury or death as a result of a sporting event which is recognized and organized by the employer. This also covers active participation in the event and rehearsals or training sessions. These sporting events may be individual or team member participation. Cover includes traveling to and from the event as long as the transport is provided by the employer free of charge. Injury or death whilst traveling is also covered. Sports claims must be reported as described in the COID Act. Cover for these injuries include medical aid, temporary total disability, and permanent disability to injured employees or fatal benefits to the dependents as prescribed in the COID Act. The Commuting Journeys Policy covers the death or injury of an employee when journeying between work and the employee's ordinary residential address. Journeying includes any means of travel on the most reasonably direct route. This policy will not cover incidents or accidents caused by the employee when they are under the influence of alcohol or drugs. This refers to drugs other than those lawfully prescribed and administered accordingly. The policy also excludes suicide, attempted suicide, and intentional self-inflicted injury. The employee will not receive cover if they participate in riots, strike, and other illegal activities, including driving a motor vehicle without a valid driver's license or driving an unlicensed vehicle. In addition, assault, hijacking, and other violent incidences are excluded. Please note the definition of the following two phrases that apply to the commuting journeys policy. Prescription. The right to benefits in terms of the policy shall lapse if the accident is not brought to the attention of the insurer within 12 months of the accident date. Franchise limit. The insurer will not be liable for any medical expenses if the medical expenses are less than R1,000. Riot and strike refers to bodily injury or death due to a riot, strike, or faction fight on condition that the employee is not participating in the event. For medical benefits to be paid out, pre-authorization is required. This includes medical procedures that require hospitalization. When the procedure is authorized, it guarantees payments to medical service providers and invoices are paid, provided they have accompanying medical reports. The same applies to persons treated as outpatients. For ongoing treatment, RMA needs to be informed of the progress of the employee's medical condition at least once a month. Days taken off work and when the employee will resume work must be indicated, as well as justification for the temporary total disablement. Support documents and any paid invoices must be submitted. Furthermore, it must be noted that a claim will be finalized after 2 years have lapsed or if the employee's condition is deemed stable. Finalized claims may be reopened. However, consultation fees will be incurred by the claimant. The attending medical service provider must find a relationship between the presenting problem and the injuries sustained on duty. Finally, a detailed medical report with diagnosis and a proposed definitive treatment plan must be sent to RMA for authorization. On these terms, should RMA accept the liability, the claimant will be reimbursed, authorization will be granted, and the permanent disability may be reviewed after receiving the medical report. This concludes the RAND Mutual Assurance Employer Information Briefing. As highlighted, it is important that RMA is provided with complete documents and correct, up-to-date information at all times. We hope that this video clarified any uncertainties you may have regarding employee coverage. Please call our contact center on 0860 222 132 should you require any more information.